Well, you all know LASPO removed all private family law cases from scope, not just eligibility, just scope. Everything in which the state was not thought to be involved, in which they included financial arrangements after divorce, which was rather foolish because those cases actually have an enormous effect on the budgets of other government departments. If there isn't a good support through family law, you're going to have more call on housing and education, more health needs. And there was also, well, we're left with legal aid only in scope where there is evidence of a public interest, including protecting a child from the effects of some form of abuse. Well, of course, this is all about money. Protecting the state from spending public money on private quarrels has been a very long-term concern at the Ministry of Justice. And it's interesting to remember that when legal aid began, legal aid for family matters was a very central plank. It was all about helping troubled families recover from the stresses of the Second World War, and helping troubled families was seen as a way of promoting social stability as a whole. No longer. It's now seen as an unwelcome and increasing drain on state resources. And do you remember that terrible phrase, supplier-induced demand, which came into fashion in the 90s, where it became a firm belief in quarters where I was hoping it wouldn't, that family practitioners who were obviously being paid for legal aid work, partly by the hour, could be escalating conflict in order to increase their income. Hence the arrival of mediation with being greeted with champagne and whistles. But the reality was, and you have to remember that MOJ was a department, it was more like a chambers. It was the Lord Chancellor with his lawyers. There weren't people who counted things or analysed things in the way that they certainly do now. At the time, it was really not realised that the increasing calls on the legal aid budget from the family side were to do with the divorce rate increasing. It was increased in case volume, not increased cost per case. And as I suggested, they knew very little about the impact on the legal aid budget of poor decision making by other government departments. Benefit claims by DWP gave rise to, I have heard the estimate of 30% of the civil legal aid budget. So it's not your fault, dear lawyers. I spent a lot of time watching you, writing down every time you breathe, pick up your pen, whatever. And certainly the traditional family legal aid solicitors were doing very much what mediators do, except that they did it from a position of a bit more knowledge and clout. They were far more like social workers. Settlement was the primary aim, and in fact, any economic incentives coming into play point in that direction. The more cases you settle, the more quickly you do them. That's what increases your income, not fighting one case to the death. Well, we are now with LASPO in, I think, a very difficult position. Although legal aid is, in theory, at least accessible for these difficult child arrangements in private law cases where there is clear evidence of abuse, it's still there's still a bit of concern about the availability of legal aid for parents in public law cases where the Section 20 cases, which seem to be increasing, where the local authority is anxious to avoid the cost of a care case, and so will try to encourage parents to go for a voluntary placement. And with a Section 20 case, there's no place at all for legal aid, even though a legal agreement is being made without any certainty that parents have been well informed, and none of the kinds of safeguards and protections which would be there if it was a compulsory care case. So family matters, as you all know terribly well, are not clear cut. And I think it is clear that there is a crossover from private to public law issues in some particularly contact disputes where elements of abusive behaviours may be present. Things like coercive control, which are very hard for a non-lawyer to understand or define or describe. Parents and children, I think, need access to legal help in these circumstances in order to be safe. So I don't think I need to say any more. I'm sure nobody's going to vote against my cunning plan. The tricky part is how we actually, we have desirability established, its feasibility is the worry. So let me share my thoughts. If we look back at what government is actually trying to do in family law, if you look at the strap lines of the department, it's quite helpful. At the time of the Children Act, the strap line was, we are here to protect the vulnerable. Lovely, needs-based, proactive, no quarrel with that. By 2010, when we're heading into austerity, when David Norgrove was beginning work, the strapline had shifted to seeking fair and informed settlement, which has a sort of nasty air of acknowledging the pressure on resources and trying to avoid court costs. In fact, the crossover cases, private dispute between parents about contact involving child protection issues, was raised and flagged up in the Norgrove report in 2010, but ignored by LASPO 2 years later. But in March this year, you may well remember, the President of the Family Division, in his judgment in Re, H&N and others, that was March 30th this year, paragraph 3 stated, the Family Court received 55,252 applications by parents for a child arrangement order, seeking to resolve the disputes with the other parents about future care arrangements. And then he said, although the figure is by no means firm, it is thought, didn't say by whom, that at least 40% of private law children cases now involve allegations of domestic abuse. 22,000 cases a year, he said. Well, that is shocking, and I want to talk about it. I think there are two steps that need to be followed. Oh, sorry, what I should have completed my strap lines. You know, it's now it's all about promoting the principles of justice. Well, jolly good. How are you going to do that then? Is the rather unspoken bit. So let's think about how we might define what cases might be eligible as crossover cases, having as private law with a public law element, and how could we estimate the potential numbers of cases. It's no good trying to move forward unless you can give some indication of costs. Well, I think there are now suggestions about eligibility, and I'm treading very carefully here because, I mean, the obvious route is to say, well, we have safeguarding letters before every FHEDRA. CAFCASS is doing a great job, just ask them. Tempting, and in no way is CAFCASS I have to be terribly careful. I don't want to land anybody in anything. But when I have discussed this with CAFCASS, I have not been discouraged from making these suggestions. We'll leave it at that for now. So I think there would be ways of avoiding the issue of being confronted by the argument that, well, CAFCASS will just recommend that everybody has legal aid, because CAFCASS knows as well as everybody else that making legal aid available at an early stage actually reduces reliance on the court, and cases are more likely to settle if they've had some early advice. So I don't think there's a problem there, but there's a presentational problem in saying, oh, look, Cafcass is going to just give everybody legal aid. Cafcass can't quite do that, but there could be steps in between, which might make the existence of a concern about the welfare of a child within the rules. And luckily, we have very clear ways at present of seeing whether there is some indication. We don't have evidence in the sense of orders made, as in domestic violence claims by adults, but there are ways of seeing what's there. And we've had very interesting evidence from Jane Krishnadas from CLOC about, if you look at the C100 applications over the last year, she has dealt with, I think she says now 50% of the C100s made to Stoke-on-Trent Family Law Court basically since COVID. And a third of those referrals to CLOC are coming from local authorities, 20% from GPs and domestic violence services, and others from Cafcass and other sources. So there is evidence of concern, and evidence of ways in which this concern can be channeled, although likelihood of CLOC becoming national is a distance away. So I think we can define these cases. We can already see ways in which these cases are moving towards seeking legal aid, and CLOC has been remarkably successful in actually supporting local solicitors in making legal aid applications. And without CLOC, there would have been no awareness by the clients that this was possible. There wouldn't have been time or energy in a hard-pressed family service which used to rely on legal aid and now is struggling to spend the time on processing a legal aid application with very little chance of success. But with support from these very well-trained students from Keele and now other universities, they're willing to spend the time and are achieving quite a lot. So I'm saying it can be done, but what would be the bill? How many cases can be documented nationally as crossing this boundary between public and private law? Well, we have the President's estimate. I'm not quite sure what it's based on, must ask him. But we do now have national data from Matthew Jay and his team at UCL. I'm sure some of you are familiar with them. They have a unit called the Legal Epidemiology Unit, which I think is absolutely wonderful. Because we've been needing that for a long time. And they report on using administrative data to quantify overlaps between public and private law in England. Report to the Ministry of Justice on the Children in Justice Data Share Project was published in 2019 with Matthew Jay as the lead author. He's very willing to talk about it to anybody who's interested. And what they did was use the new data share which MOJ instituted when actual research funds were limited. It's very clever to turn to administrative data and see what you can find. So using MOJ court data, Cafcass data, national pupil-based data, children's social care data, they have worked over 5 years identifying children involved in private children cases, get a description of the index case, and then quantify how many later become involved in public law proceedings. So that would be the bare minimum of children who should be accessing legal aid earlier. And also there's a group who return to court but for private hearings. They looked at about 35,000 cases a year in private law over that 5-year period, 2011 to 2016. It's about 55,000 children a year. 18% of those in private law proceedings in 2011 went on to more private law proceedings by the end of the 5 years, and 3.5% had become involved in public law family cases during that period, usually ending in a care order. So even with the Section 20 initiative, as it were, there still are a number of cases beginning in private law and ending up in public law within a reasonably short period. And if you divide children with welfare concerns at the time of the index case and those without, there was a difference in their later experience. So this would, the group with welfare concerns early on would be the ones we would catch if the scope of legal aid was just bent that little bit. It's something like, there we go, it's 18% with welfare concerns in 2015 returned to court. And of those who didn't, 24% who didn't have welfare concerns returned to court. So it's the children with welfare concerns at the first private law hearing were less likely to return to court than those without, which you might think is odd. Could just be statistics, it's quite a small difference, but it could well be related to those with concerns at the first stage, having received help earlier. And there was very little difference in the reasons for return. So my question is this what we call an AQWA, AQWA? Is this, can we improve access to legal aid for these children? Is this a question worth asking? Is there any chance of getting anywhere with it? And I think I have had encouragement from CAFCASS. I've had encouragement within the department to continue thinking about this. I can say no more. And then I was enormously encouraged. I don't know if you read Family Matters, the FLBA journal. This summer, page 20, summer 2021, the Lord Chancellor was interviewed by Rhys Taylor, who said to him, given the universal condemnation amongst lawyers, judges, of the effect of the withdrawal of legal aid in most private family law matters, is there any possibility that further consideration could be given to this most vexed topic? And the Lord Chancellor began his reply by making it quite clear that he wasn't going to tear up LASPO. But then he referred to the post-LASPO review of 2019 as an important staging post and said, we are looking to make sure that in the spirit of that review, we are testing different interventions that really focus on the most needy and vulnerable. And he closed by saying, the most interesting point for me is what I'll call the crossover cases, where what starts as a private case development of what we call public law cases where what starts as a private case develops elements of what we call public law cases. What about these particular cases, he said, and how to deal with them? Well, hurrah, I thought. Let's have a go. Let's really make an effort and try and get these crossover cases put back in scope of legal aid. It's the least we can hope for.